Hello and welcome. My name is Miles Celic. I'm the Chief Executive of TheCityUK, and I'm delighted that you're able to join us for the launch of our Blueprint for International Trade Agreements and Immigration Policy, which TheCityUK has produced in collaboration with EY. I'm especially pleased that today we'll be able to be joined by the Immigration Minister, Kevin Foster, and our panelists, Mark Garnier, MP, and Professor Catharine Barnard. I'm also delighted that we'll be joined by members of the EY team who we'll be hearing from, and a special thank you to our friends Seema, Farazi, Sally Jones, Tim Whitaker, and all the team at EY for the work that they have done on this report. I also want to take this opportunity to thank the TheCityUK members who've contributed their time to the report during a period where a huge number were enormously busy managing staff stranded overseas and dealing with the HR and migration related impacts of COVID-19. Talent, both homegrown and from the rest of the world, has always been a priority for the financial and related professional services industry. Our people come from across the globe to join some of the most experienced industry practitioners in financial and related professional services that are gathered anywhere. The industry has benefited from its ability to attract the best talent, not just from abroad, but also from at home, and being able to recognize that expertise across jurisdictions. COVID-19 and Brexit have understandably created challenges when it comes to talent. But it's also proven how agile and responsive our immigration system can be. One of the TheCityUK's strategic goals is the long-term competitiveness of the UK, and trade agreements and immigration policy are two vital foundations crucial to retaining that competitiveness. So we welcome the UK's new immigration policy, which is set to come into force on the 1st of January, which has adopted 6 of the 9 recommendations that we set out in our first report on this subject with EY. But there remains more that can still be done. And the UK now has a unique opportunity to push traditional boundaries on international trade and immigration policy as it approaches its new global trading partnerships. With both immigration and international trade and investment policy in the UK at a momentous juncture, now is the time to take those constructive, innovative steps to seize the opportunities that are before us. So we hope that the report that we are launching today provides a helpful contribution to that discussion to help underpin the future success of our industry and our country. So I'm delighted now to hand over to Sally Jones of EY to give her opening remarks on their behalf.
Thank you very much, Miles. It's a pleasure and a privilege to be part of this webcast, launching what I truly believe to be cutting-edge thought leadership from the TheCityUK and from EY. The truth is, we find ourselves in a brave new world, in new and sometimes choppy waters. And this requires of the UK government the need to launch independent immigration and trade policies. It requires UK businesses to build their own dynamic strategies to allow them to navigate the currents of rapidly evolving opportunities and change. But perhaps most importantly of all, it requires each of us to find new ways of thinking, of linking concepts that we have perhaps previously thought of in isolation, if I were to steal a phrase, as islands entire of themselves. Immigration and trade policy are 2 such islands, and mobility is the bridge that will link the 2 of them. It's really important that we find common language, common frameworks, common policies, and allow them to be implemented consistently and practically. And this work is an important and exciting part of that journey. I come from a trade background. I spent most of my career huddling in back rooms with nobody wanting to talk to me because everybody knows that trade is boring and dull. And then the Brexit referendum happened, and all of a sudden I found myself in a world where people wanted to talk to me, and I had friends. One of the most exciting things that came about from that change was to meet people like Seema Farazi from our immigration team, and to discover that we have so much more in common than we have apart, and that if we come together, we can come up with bold and innovative and deeply operational and practical ideas. I truly believe that this report is important. I truly believe that this report will influence the way that companies and governments think, and that if we take advantage of this new way of thinking, we can come up with bold and new ways of moving forward in a new world for our country. Miles, thank you very much for inviting EY to work with you on this report. Thank you very much for having us on this webcast. And thank you very much for allowing us to be part of such an exciting project.
Sally, thank you very much indeed for that and for those opening remarks on behalf of EY. I'm now absolutely delighted to be able to turn to our keynote speech, which is delivered by Kevin Foster, the Minister for Future Borders and Immigration. Minister, we're absolutely delighted that you're able to join us for this. Over to you.
Well, thank you, Mars, for the introduction. I want to start by thanking EY and the City of London Corporation for inviting me here today, albeit in a virtual capacity, to the launch of the follow-up report to the paper you published back in 2018 on building a world-class visa process for our United Kingdom. In starting, I would say it's great to see how engaged you have been with the Home Office as we design and implement a new points-based immigration system. A new system has been designed with business in mind and will provide simple, effective and flexible arrangements for UK employers to recruit skilled workers from across the world through several different immigration routes. I do look forward to hearing shortly the findings of your newest report, the International Trade Agreements and UK Immigration Policy, a Blueprint for Evolution. You know, I am, and the Home Office is committed to working together with businesses as the government introduces the new system, which we want to use to attract talent, give us control of our borders, and deliver a high skill, high wage and high productivity economy. We believe this is what the British public voted for, and it's vital we now deliver on the people's priorities. As you'll all be acutely aware, and as has already been referenced during this event, the coronavirus pandemic is the biggest national crisis we have faced in our lifetimes. And in these uncertain times, it has become even more important for the government to deliver its promises with clarity. In February, we set out our vision for the future immigration system and are now delivering change to support our economy twofold. Firstly, by encouraging investment in the domestic UK workforce in the first instance, and secondly, for ensuring businesses can attract the brightest and best from around the world via our immigration system. We are clear we want employers to focus on training and investment in our domestic workforce, especially those needing to find new employment as a result of the impact of the measures necessary to tackle COVID-19, rather than in the first instance relying on labour from abroad. Yet at the same time, we are also looking to make it simpler for employers to attract the brightest and the best from around the world to come to the UK to complement the skills we already have here, or where there are shortages in skills available in the UK labour market. The UK's new points-based immigration system is a key part of the recovery from the pandemic, and as we say, it will support a wider economic strategy by both encouraging domestic recruitment, but also providing access to skills that are needed to be recruited abroad. And we do believe it will give employers and businesses greater flexibility, as well as removing some of the more pointless complexity and bureaucracy that's built up in the system over years. And we firmly believe there are three tenets to the new system. It'll be fairer, because we will treat people from every part of the world equally, welcome them based on the skills they have to offer and how they will contribute to the UK, not on where their passport was issued by. Firmer, because we'll have control of our own borders from the 1st of January and be able to decide who comes into the country to work. And skills-led, because the system will value the skills people have, with points awarded for a job offer at the appropriate skill level, the ability to speak English, and meeting the appropriate salary thresholds. We did publish more detail on the UK's point-based immigration system on the 13th of July, and the reason for publishing that further detail was to enable businesses time to prepare for the new system going live on the 1st of January. Although to be clear, we will implement the new system in phases to ensure smoother delivery. We're clear that this system is going to play a key part in our long-term approach to the UK's labour market as the government brings forward its strategy to rebuild our economy, support businesses to grow and get people back to work. Although to be absolutely clear, we are not closing the door as some would portray. We are designing a system where we can choose who comes through it based on the positive impact they can have to our country, again, not on where their passport was issued from. And these new measures open us up more fully to the rest of the world with a single global system for those seeking to come and work in the United Kingdom. With this in mind, I wanted to reflect on the new skilled worker route, which will be perhaps the key part of this system that will go live on the 1st of January. And in response to the recommendations from the Independent Migration Advisory Committee, we will, from the 1st of January, abolish the rather burdensome resident labour market test, suspend the cap on the number of skilled workers, and reduce the general salary threshold from £30,000 to £25,600 per annum, and change the skills threshold from RQF6 degree level to include RQF 3 to 5, pretty much school leaver equivalent. And this is partly to be clear that we want to bring in a wider range of skills that we know are essential, rather than the more purely academic ones that a degree level threshold implies. And the first two changes I've just outlined will mean the process to bring in a person to fill a qualifying role will initially be reduced by up to 8 weeks, and we intend to further reduce this in additional enhancements to the system beyond January 21. Under the skilled work route, each applicant must score at least 70 points to be eligible, and 50 of those points must come from meeting the mandatory criteria, for example, being able to speak English. However, we will allow people to trade points. For example, those who don't meet the salary thresholds can still come to the UK if they can prove they have a job in a shortage occupation or a PhD relevant to their role, and with a doubling of points if it's a STEM PhD relevant to their role. Some occupations do have higher salaries than the general salary threshold, so to avoid undercutting of the UK labour market in these areas, for those occupations, the relevant salary is the going rate, not the general salary threshold of £25,600 a year. Applicants with particular characteristics can also use some tradable points to secure a discount, both the general salary threshold and the going rate for the job for clarity. So, for example, new entrants to the market or having a PhD. And that has been a question some have asked. And also to clarify, we've given some of the rather misleading media coverage on this point. Several mostly public sector based occupations, such as teachers and nurses, will score 20 points by being paid a salary in line with the relevant published national salaries of their profession, subject to a minimum threshold of £20,480 a year. So to be clear, that's effectively the NHS's salary thresholds. And we're also clear that skilled workers will be able to switch easily between employers with a sponsorship licence. And then for those who wish to settle more permanently in the UK, we will be revising the salary requirements for those applying for settlement, having completed 5 years under the skilled worker route or under the current existing Tier 2 general route. The current salary requirement for settlement is £36,200 a year. This will be replaced by a requirement to meet the general salary threshold for the skilled worker route, which is currently will be £25,600, and the going rate for the role they're working in. Notably, there will now be no limit on the number of years a person can stay under the skilled worker route, nor will there be cooling off periods after them having had a visa on that route. Turning to the sponsorship process, we are committed to delivering some radical changes to this and streamlining it and simplifying it for users and substantially reducing the time it takes to bring a person to the UK. While these reforms will be rolled out as part of the Home Office's multi-year programme of change to our border and immigration system, so some substantive changes will be in place for the 1st of January 2021. For employers sponsoring skilled migrants, the process will be streamlined to reduce the time it takes to bring in a worker by up to 8 weeks, and we intend to reduce this in additional enhancements to the system. As already mentioned, as a first step towards reducing the burden on employers and streamlining it, we will suspend the current cap on Tier 2 visas, which will result in there being no limit on the number of skilled workers who can come to the UK, provided they meet the criteria that I've already set out. We believe this change alone will reduce the end-to-end process for sponsoring skilled workers by up to 4 weeks. Crucially, employers will no longer be required to pass through the monthly panel system, the process currently used to prioritise occupations under the existing cap, when seeking to secure a restricted certificate of sponsorship for those applying from overseas. To be clear, sponsors will still need to apply for a RCOS before sponsoring a skilled work application. But as a result of the removal of the panel, this may be completed within just 1 working day of receipt. To provide employers and prospective future sponsors with certainty, we will continue to apply existing sponsorship controls to maintain high standards over whom we license to bring migrant workers to the UK. And we aim to ensure applications can be made under the new route before the end of the transition period to allow people to have their permission to be in the UK in place before the 1st of January. And to be specific as well, what I expect will be welcomed is that existing Tier 2 general and intra-company transfer sponsors will automatically be granted a new skilled worker licence with an expiry date consistent with their current licence and receive an appropriate allocation of certificates of sponsorship. And sponsors with certificates of sponsorship will be able to immediately sponsor workers under the new route, including being able to sponsor occupations at the new skills threshold of RQF3 equivalent. And to further streamline and improve the experience, from 2022, we will be making some further reforms to the sponsorship system. And we're particularly going to be looking at how we will distinguish between regular and occasional users to enable us to offer a more tailored process with varying degrees of obligations and compliance arrangements. We believe this will level up the new system even further through better use of risk analysis, trust ratings and data sharing across governments. And we will of course intend to work with businesses further on these improvements. They'll be welcome. The changes will be followed by further improvements in terms of the operation of the UK border, including in the longer term, the introduction of electronic travel authorities to ensure those coming to the UK have permission to do so in advance of travel. We'll take a phased approach to ensure the smooth delivery of this new system and to allow sufficient time for everyone to recognise the core links there are between ensuring we can trade effectively internationally and ensuring that people can, when coming to the UK, have a welcoming experience when they arrive at the UK border. As part of the skilled worker route, the intra-company transfer route is designed to enable temporary transfers of key personnel to the UK arm of a business to meet a specific business need in circumstances where it won't be feasible to recruit a resident worker to the role. We believe our current arrangements for ICTs are competitive in international terms, offering up to 5 years length of stay for managers and specialists. And in 2018, 32,000 intra-company transferees were issued with visas. We are looking at how we can improve on the current offer for business mobility as part of the future immigration system, and we'll ensure it continues to support trade investment through global businesses being able to move their talented people when they need to. Because we recognise that ensuring overseas businesses can deploy key staff in the UK to support services and investment activity is an important part of, in fact, attracting trade and investment. And we are looking at some of the changes we can also make around how some of the rules work in relation to cooling off periods and time in the UK. Again, to facilitate some of the flexibility businesses operating services across borders need to have. We'll perhaps briefly touch on the part of the scheme that has already launched our new system, which is the reformed global talent route, which we launched on the 20th of February, and that expanded upon the Tier 1 exceptional talent route. As part of the reforms of that route, we removed the cap on the number of workers and expanded the list of eligible science fellowships to benefit from accelerated entry to the UK. And the reason why we were keen to launch this first is that we wanted to send a very clear message about how we wanted to see that ability when tackling some of humanity's biggest challenges from a research perspective, that teams based here in the UK could be recruited literally blind to what the nationality was. That hopefully people have found useful as a sign of our ambition and intent. And in the future, we are also looking to create a broader unsponsored route within the points-based system, which will run alongside the employer-led system. And the goal of that will be to allow some of the most talented people in the world to come to the UK without a specific job offer. We are exploring some of the proposals for this route with stakeholders over the coming year, and we will share some further details, but certainly we're looking forward to the feedback we can get from seminars and from groups like this one. And then finally, perhaps I'd say a little bit about our new graduate route, which will launch in summer of next year, 2021. This will allow international students to stay in the UK once they've completed their studies. So to be clear, this route will allow students who have completed undergraduates and master's degrees to be able to stay for 2 years. and those who've completed a PhD for 3 years, to make it easier for those, some of the best and brightest international graduates to stay in the UK, potentially to start a business, potentially to innovate and to pursue particular projects, and to be reassured that in any time during that period, once they qualify, they can swap into our skilled worker route, which then is a route to permanent settlement here in the UK. There's also, I think, alongside some of the more famous changes that we're making, we're also undergoing a major process of simplification of many of our immigration rules. And I hope when people see the student rules go out, hopefully this week, there's the next part of our new system to launch, people see some of the steps we're making in that area to really try and make the immigration system a lot more user-friendly than it's become, and to, again, for applicants, give them a smoother process and an easier ability to understand what we need to provide to the Home Office, and likewise changing some of our rules that perhaps don't reflect the ambitions we have for the new system. So in conclusion, we are providing certainty to the new system now to further inform businesses planning, particularly with those who've had little to no previous interaction with the UK's immigration system. Officials are working with businesses, SMEs, community groups and users to raise awareness and understanding of how the new system will operate, and we're also closely working with our colleagues in the Department for International Trade to discuss how the migration elements of facilitating trade can work alongside their efforts. Further guidance and the actual immigration rules themselves will be published later this year, and we do intend to open the key routes from autumn so people can start to apply ahead of the system taking effect in January 2021. I hope this short speech has given some further insight into the new immigration system, and we want to assure people that the goal of the new points-based system is to ensure Britain remains open for business, is clear it is a place where you can do business globally, and is aligned with our economic objectives as well. And that ultimately it's about making sure the brightest and the best see our United Kingdom as the place where they can explore their talent, their potential, and develop their opportunities. Thank you.
Minister, thank you very much indeed for those extremely helpful remarks setting out where we are and the direction that we're heading in on immigration policy. That's been hugely helpful. And thank you on behalf of the membership of TheCityUK for all the work that you and your colleagues have been doing in this policy area. It's now my great pleasure to turn to Seema Farazi, the partner at EY, to present the recommendations in the report. Seema, over to you.
Thank you so much, Miles. Thank you also, Minister, and thank you very much, Sally. Good morning to all of you, and thank you all for joining us. I think it's appropriate to start by saying that when we commenced this work, the UK was already facing its most momentous immigration reforms in almost 50 years, which the Minister has kindly taken us through just now. But it's fair to say that in the last 6 months, international trade and immigration systems have been tested in different but equally unprecedented ways. And we published this report really in a transformed world. That at once creates a perfect storm, but also a perfect opportunity to reframe thinking around some of the issues that have historically challenged. And if ever there is a time to evolve the discussion, to look at those long-standing challenges in a changed way, we think that time is now. We do so in the report very much through a constructive lens. There are no doubt aspirational reforms that can be delivered at the WTO level. But here, what we've tried to do is really set out how you can remove some of the mystique, some of the complexity and technicalities that sit around global trade agreements and migration policy, and really cut straight through to the realms of practicality. So we focused on what we view as immediately achievable measures that deliver tangible benefit to the industry, measures which evolve policy, but which do so without presenting any inherent conflict with the principles underlying the architecture of the system, which the Minister has just described. And we're very grateful to you, Miles, to the team at TheCityUK, in particular Philip Jones, Laura Dawson, Richard Hill, John Cook and Alex McFarlane, and the members of TheCityUK for their enthusiastic engagement throughout the preparation of this report. And as you said, Miles, giving their very valuable time at a difficult period for everyone, which I hasten to suggest of itself, it talks to the importance of the matters at hand. I would like to also echo, Miles, your thanks to our brilliant EY team for their research and hard work in pulling the report together, in particular Tim Whitaker and Kelly Sullivan. Thank you all. On to our findings. We started this report very much where we finish it, on understanding business need, where the gaps are, and how to reasonably and achievably fill them. There are 4 aspects to this: usability, innovation, deliverability, and effectiveness. And it's important to set the scene for our recommendations with 2 key observations around where we are at this point in time on both trade and immigration, which we say actually create unique opportunities. Firstly, in pandemic responses, we have seen that immigration policy can indeed innovate and move at speed. Rapidly introduced government flexibilities, which were designed to protect those impacted by the crisis, has shown that it is possible to reimagine old ways, to flex the architecture without breaking it. And the UK did very well here. It granted automatic extensions for essential workers, ripped up the rules on switching, and allowed virtual right to work checking, among other measures that were designed to support both the impacted individuals and businesses alike. Beyond the UK too, over 50 countries abandoned the red tape that we're used to seeing and granted automatic extensions to protect business travellers and migrant workers from becoming overstayers. And at least 20 countries moved to online processing in the interim at least. Second observation, global trade frameworks are often comparatively less agile, even at a time of crisis response. And international trade too has been tested to limits in very different ways, with distressed global supply chains and demand shock, nearshoring to protect against future supply chain shock, limited or targeted onshoring, for example, around medical supplies and PPE, and conflicting impact on even the leanest of just-in-time supply chains. But in international trade, policy has not typically moved at such speed as we've seen in immigration. And efforts involving migration policy within the global trade framework have as yet not produced overwhelming outcomes. And that is really an important point in the current context, in understanding what is the right mechanism by which to deliver effective change to plug business gaps. So what are those gaps? As we heard from the Minister just now, the UK's immigration system is on the cusp of a new unified system for all UK nationals. And that system will indeed represent a significant gain on its Tier 2 predecessor. The graduate route is particularly welcomed by business. And as Mal said, challenges nonetheless remain, and we've continued to hear that through the engagement, particularly around cost, accessibility, and administrative burden. If we move on to the next slide, delivery of the UK's unified system on the 1st of January is of course but one stage in a concerted move to continue to revise and improve the system in its totality. That's fantastic news. It's great that there is a commitment to look at trade routes to make improvements to their current form. It's very good news that in July an Office for Talent was announced with the aim of ensuring the UK's talent offer is stronger than ever. It's great that we're looking at building an unsponsored route on improving the administration of the skilled worker system, enhancing a user experience, and developing the UK's 2025 border strategy to deliver a world-class border. Mobility agreements, however, with trading partners have the potential to alleviate some pressures for the industry and some of the gaps that we still see. And the UK, of course, derives a broad range of economic benefits from effective mobility provisions. But fundamentally, usability is everything. Free trade agreements are only as useful as they are usable by those seeking to trade between the UK and its treaty partners. And effective FTAs in this space will require UK policymakers to be unhesitatingly innovative, crafting agreements that will be positive for business, but also attractive for business to use. It follows that key themes to guide the government on immigration reform in this space will be very much what we've heard just now: simplification, efficiency, and better user experience. And that is particularly important in this current context, as there are 3 fundamental challenges with migration policy in free trade agreements to date. Firstly, they are technically complex almost to the extreme. Secondly, they have not acted as an engine for change, and efforts at reform, as I just mentioned, have so far been rather underwhelming. Thirdly, their implementation can challenge the positive user experience that is really critical to the underlying goal. And these challenges are really diametrically at odds with what we've just heard around the factors and the themes driving UK government immigration reform. If eventual rules and FTAs are contradictory or difficult to apply in practice, there is a risk that businesses don't use them, lessening the potential economic gain from the agreement. And this is where the UK system can be complemented by bilateral agreements with other jurisdictions that implement mutually beneficial routes. One of the biggest risks, we say, that the UK faces at this particular time is not being ambitious enough with regards to services trade and really missing an opportunity to do more in this space. There is space for the UK to be innovative in its services trade policy when concluding bilateral deals, not simply be bound by WTO precedent and previous bilateral deals struck by the UK and other countries, but really to think creatively about how to plug skills shortages and unlock concessions from other countries, both in terms of the opening of service markets and proactively solving for inherent gaps in the UK's own system, creating, we say, a blueprint for evolution. Now, we recommend that the government seeks to do so in 6 ways, and our recommendations are identified in a number of different categories. So there are new or improved direct enabling routes, namely those that are provided as part of a trade relationship and to trade partners. Those that exist in domestic immigration policy and are available to all nationals, irrespective of any trade relationship. We call these indirect enabling routes in the report. In some areas, for example, service delivery, we're calling for an improvement to the UK's implementation to bring it up to the standard that we see in some other countries. In other areas, for example, process, we're calling for an improvement to other countries' implementation to bring those systems up to the UK standard. And with that in mind, I move to our first recommendation on short-term travel. What we heard from business was expectedly divergent, given what has been happening around international travel over the last 6 months. In some cases, we heard that there will be no going back to pre-COVID-19 travel patterns. From others, we heard that the accumulated capital that has been built up through face-to-face interaction is going to erode unless services can re-establish those personal relationships with clients, and business travel will be an important part of that strategy. Overall, short-term cross-border travel is seen as essential to manage teams effectively and deliver operational effectiveness. So our first recommendation, moving on. Increased certainty for UK business around short-term travel. This is an area where the UK does well. UK inbound travellers benefit from very clear and transparent rules in the UK's visitor part of the immigration rules. However, short-term business visitors to other countries are often frustrated by a lack of clear information and guidance on permissible and prohibited activities. This issue is going to be exacerbated when the relationship with the EU ends in December, with each EU member setting its own rules on permissible activity. And so in free trade and bilateral agreements, the UK should focus on the form of commitments in this area and move towards a granular list of prohibited and permissible activities to bring other countries in line with the UK standard. This may sound like a really small ask, like a small problem, but this is a significant bane of discontent for the sector. And moving towards that clear, standardised reciprocal list represents a critical step towards certainty for UK business sending British staff to the EU and other countries on business visits. Secondly, recommendation 2, moving on, again in the same space around short-term travel. There is currently no middle ground between visitor status and a work visa, and business wants there to be an appropriately controlled middle ground. We recommend a hybrid, streamlined, short-term category to allow productive work. Where a visitor into the UK needs to perform productive work, with very few exceptions, they typically cannot enter under the visitor rules and must apply for a work visa, even where the work activities are incidental or for a short period, as much as 1-2 days. This means a significant increase in administration cost and timeframes associated with applying for a work visa. What we propose is that the UK implements, on a mutually agreed basis, a direct enabling route for trade partner nationals. This has the benefit of encouraging trade without posing a risk to domestic labour markets, and combines the controls associated with sponsorship that currently exist in the architecture of the system with the flexibility of visitor rules. There would be two stages involved to this. Firstly, the controls. Applicants would be issued with a certificate of sponsorship by the UK sponsor, bound by their commitments under that licence agreement, enabling them to allow the certificate holder to perform productive work. A secondary control would be that this would be restricted to 6 months. Secondly, the flexibility. The list of non-visa nationals should be updated to ensure that trade partner nationals are included, offering a mutually agreed route. And these non-visa trade partner nationals would be able to travel to the UK for this purpose without first applying for a visa, making this a significantly streamlined option, delivering increased flexibility and speed to land and lower cost administrative burdens. Moving on to service delivery, what we heard was that the system was inaccessible. We heard from business, and this was resoundingly the opinion. We wouldn't expect our clients to become involved in sponsoring staff from a visa perspective, and we don't want to place this burden or expectation on them. What we heard from business was that they very rarely use the Tier 5 option, which is the service delivery option currently. What we propose are simplified immigration rules supporting service delivery commitments. The UK's implementation of commitments to facilitate contract service suppliers currently sits under the Tier 5 International Agreement category. It's viewed by business as overly complex, and it is infrequently used. It places an excessively high administrative burden on the UK company receiving the services. Therefore, we recommend that future trade agreements should provide more detail on the required implementation of commitments. This would avoid the way in which they are implemented, frustrating the very purpose of the commitment, which can result in trade distortion. Simplified and more consistent immigration routes for service suppliers reduces the friction associated with delivering and receiving cross-border services. An offer by the UK to implement more accessible routes that are more closely aligned with other countries' implementations could similarly be deployed as negotiating capital to secure advantages in other areas, leading to other benefits for UK organisations, including those identified in the business travel section of the report, which I have. Such changes would also have the benefit of offering UK-based customers wider choice, since the delivery of services by an overseas supplier will involve less friction and should therefore be more cost competitive. Moving on to the fourth of our recommendations, youth mobility. What we hear from business is that youth mobility represents a significant opportunity for the UK to benefit from talent capital in its economy, and also for UK nationals to travel in the opposite direction, gain crucial skills and experience, and bring those back to the UK economy. The UK's youth mobility scheme works very well and provides a convenient self-sponsored route that gives employers some relief from reliance on the sponsored worker system. So far, the UK has not agreed reciprocal youth mobility arrangements with the EU. The risk is, we heard from business, that without such agreements in place, the end of free movement risks bringing about a potentially overwhelming reliance on the UK sponsored worker system, with its associated administrative burden and cost. What can be done? Well, the UK should prioritise the agreement of reciprocal youth mobility arrangements with all trade partners, but particularly the EU. Youth mobility visa holders can proactively move to the UK. UK youth mobility visa holders can proactively move to trade partner countries, and widening the scope of the route will help support a significant pool of UK-based international talent, leading to a lowering of the overall burden on UK employers, but also enhance the skills that UK nationals are able to obtain overseas. Recommendation 5, our penultimate recommendation. Intra-company transfers, which the Minister mentioned in his speech. What we've heard from business is the intra-company transfer route, which is currently open to all nationals, does not truly reflect the temporary nature of the employee's presence in a host country in the category. Under the route, short-term assignments to the UK of between 6 months and 2 years attract significant additional costs via the immigration skills charge. That cost increases friction associated with short-term assignments and reduces flexibility for UK employers with branches overseas. What we recommend is that the UK offer a bespoke intra-company transfer route for nationals of trade partners where reciprocated. There would be two key differentiators from the current intra-company transfer route that would deliver significant benefit to UK industry. Firstly, the applicant would be required to be a current employee of an overseas branch of the UK sponsor, but would not need to have worked for them for any specific length of time. This is one of the flexibilities that we've previously seen in the UK system under the Tier 2 ICT skills transfer route that used to sit under the category. Secondly, the route would offer a 2-year exemption from the immigration skills charge, saving employers up to £2,000 per person for people sponsored under the route. Alternatively, a reduced rate could apply for trade partner nationals. Either the category could be limited to 2 years, or where an assignee extends the assignment beyond 2 years or localises the ISC should be payable from that point onwards. And this is in recognition of the fact that the skills charge was implemented to reduce demand for migrant labour and really incentivise employers to invest in training UK staff. The principle of Mode 4 commitments is, of course, that natural persons making use of the provisions are not entering the resident labour market in any event, and therefore do not represent a threat to the local labour market that the implementation of the charge should be seeking to resolve. One of the benefits of this route would be to offer international organisations with branches in the UK and overseas greater flexibility, both in arranging short-term assignments and facilitating also the delivery of services by their overseas branch to a UK customer. And of course, it would give the UK greater flexibility to negotiate favourable agreements for outbound movement too. Finally, moving on to our 6th recommendation. And as I said, we finish very much where we started on the issue of usability. Our 6th recommendation is around the adoption of clearly articulated and accessible principles. It sounds simple enough, but it is not yet delivered in the context of trade and migration policy. Employers tell us that the processes and procedures associated with applications, particularly those that flow from trade agreements, are often overly complex. And we're talking here about both into the UK, but particularly also out of the UK, with poor published guidance and high levels of uncertainty over when, if at all, the right visas and permissions will be granted. These challenges increase friction in the cost of administering applications and decrease certainty. And therefore, the UK should seek to agree with trading partners via agreements the adoption of a standard set of principles governing how applications are submitted and processed, and actively promote awareness of opportunities. This would include substantive commitments on speed, processing, decision-making, supporting documentation and cost, with consistent, clearly communicated processes in different countries, greatly reducing the friction associated with international mobility. So I've just covered the last slide, which was the recommendation 6. But if I can conclude really by saying that we're very encouraged by measures that are being taken to deliver real innovation around immigration policy. There is a lot of good news, but the UK has a unique opportunity now to push traditional boundaries as it approaches new global trading partnerships and relationships. If the opportunity is taken, enhanced frameworks for the UK's financial and related professional services industry can be delivered. This is an opportunity that may well not reoccur. With both immigration and international trades at a momentous juncture, there is a fresh opening for new, constructive and innovative approaches, working with a grain of existing systems, flexing current architecture in both. One of the biggest risks, we say, is not being ambitious enough with regard to services trade and missing an opportunity to be more creative in this area. UK policymakers should look beyond precedent and previous deals and be innovative in its services trade policy when concluding bilateral deals. And with skillful handling, the UK can take a lead here in setting global normative standards with trade partners to bring about effective and mutually agreed immigration frameworks. This will be an essential contribution to fulfilling the objective of enhanced access to trade and services for the industry. It's not yet clear what the cumulative impact of the pandemic and leaving the UK and striking new trade agreements is going to be. However, we are confident that our recommendations will help direct the UK's international trade policy making on migration towards operationally achievable strategy around immigration that provides business-friendly support for the financial and related professional services industry and wider economy. Action now will have a long-lasting impact on the UK's trading future, and we really encourage the government to look thoughtfully at the recommendations and move forward with progressive reforms. Thank you so much, Miles.
Seema, thank you very much indeed for that presentation. A terrific run through of the recommendations in the report, and again, huge thanks to you and your team for all the work that's gone into that. To discuss the themes that came up in the report, the feedback that we've had, the comments from the Minister, and this important subject more broadly, I'm delighted to be joined by a terrific panel. We have with us Professor Catharine Barnard, Mark Garnier MP, and Sally Jones to go through this. I'll introduce them all in a moment, but just a reminder that you are able to use the function on Zoom to put questions to the panel. I'll ask them to make a few introductory remarks in a moment, but please do have those questions coming through. In fact, I think a few more are coming through already. Just as a quick introduction, Professor Barnard is the Professor of European and Employment Law at Cambridge University and a Fellow of Trinity College, Cambridge. She's also a Senior Fellow at UK in a Changing Europe and a distinguished commentator on these issues. Mark Garnier is the Member of Parliament for Wyre Forest and a member of the International Trade Select Committee, previously having been a Minister in the Department of International Trade and a member of the Treasury Select Committee. And prior to entering Parliament, he worked in a number of senior positions in financial services. And Sally Jones, from whom we've already heard, is the trade strategy partner at EY and leads on the company's trade strategy and Brexit activity, and is also chair of the Trade Technical Working Group of the Professional Businesses Services Council, which works extremely closely with government on trade issues. Sally has already given us her opening comments, so I'll turn Professor Barnard to you for your initial views.
Thank you very much indeed for the invitation, and thank you in particular to the team for a terrific and extremely detailed report. As the report points out, this is a highly technical area, and I think they've done a really very good job in trying to encapsulate some of that technicality, but also to show some productive ways forward. I would like to make 4 brief points, if I may. The first thing I would like to say is I'm very glad to hear the Minister talking about simplification, and in fact the EU settled status scheme is a very good example of where simplification can work pretty well. And I sincerely hope that this scheme would be rolled out more widely for use in the immigration regime. Now, of course, I know it's intended for a very specific purpose, namely to assist those who are applying for settled status, such as EU nationals and their family members who are in the UK and will be there before the end of the transition period. If you are computer literate and you have a decent phone, you can apply for settled status with great ease, and it comes back up until very recently with an agreement on your status very quickly. The one area where it's not working well, which is of direct relevance to what we're talking about now, is in respect of third country national family members. So this is where a Polish national is married to a Brazilian national who is currently working in the UK. A lot of them aren't actually applying, so they don't realise they should, but of those who are being rejected for any form of settled status, 50% of those are third country nationals. So there clearly is a problem of some sort dealing with third country nationals. But I must say, the scheme itself, the high school group, has worked extremely well indeed. My second point relates to short-term business travel, and it's certainly one of the interesting asks that the UK has put in the draft free trade agreement, if it is ever successfully concluded. If you look at Article 11.11 in the draft agreement, it certainly allows for short-term business, but it is really heavily hemmed in with caveats. And those caveats make it really quite difficult to operationalise if you are trying to provide a temporary service abroad. At the moment, you can't be engaged in selling goods or services to the general public. What does that actually mean in practice? How is it going to work in the case of businesses sending their staff or the staff going in order to look for a business, and they might be providing some advice at the time? It says you can't receive remuneration, but what happens if the remuneration comes in a different form later on, and so forth. All of this makes things really very difficult indeed. And a very small footnote here, when I speak about Brexit, one of the questions I'm most often asked is about jobbing musicians who temporarily go to Paris to perform at the Paris Opera House. They say they can't do that under any of the plans at the moment. This will really significantly limit what they can do. Yes, that's not for this audience, but there are other groups out there who are in a similar difficult position. My third point is about longer term migration, and that is about the costs of the current scheme. It's alluded to in the report, but if you think about it, and this is the world in which I operate and function, you've got someone coming for 5 years and he or she won't come without their family and their child. The costs for that group of people coming currently under the Tier 2 scheme are really very significant indeed. Just as a reminder, it's £1,220 per person for a 5-year visa, plus £2,000 per person for 5 years for the health surcharge. And then there's a skills surcharge as well for the main applicant. All of this brings you into a cost of somewhere in the region of about 15,000, 17,000 if you are paying for both the skilled worker plus spouse and 2 children. It really is significant, and is a significant deterrent for welcoming very high skilled people. My fourth and final point is about remedies or dispute resolution. At the moment, under existing EU law, if I have problems with the French authorities and they are mucking me about because they're not allowing me to do what I want, which is currently allowed under EU law, I can go to a French court and get the matter sorted out. Under any future trade agreement, of course, it will be a state-to-state issue. And that means that if the French authorities won't let me do what I want, or won't let my firm send me for whatever reason, I have to lobby the UK government to get the UK government to start any process, whether it be under any free trade agreement or under the GATS regime. All of this is immensely time consuming, and the reality is people don't do it, which is why there's virtually no cases at all under the GATS. And one of the things I would strongly recommend is that in your recommendations you think about something more about dispute resolution, which is missing from the report. But otherwise, I think the report's excellent, so thank you very much indeed.
Professor Barnard, thank you for that. I believe that we're about to lose the Minister, so I just wanted to take this opportunity to say thank you very much again on behalf of the City UK and its members. Very much appreciated having you join us, Minister.
It's been interesting, and I hope you enjoy the rest of your session. Thank you.
Brilliant. Thanks very much. Turn now to Mark Garnier for your introductory remarks on the panel. Mark.
Well, look, thank you. And again, can I sort of add my comments to both EY and City UK for coming up with this incredibly useful report. I haven't had a chance to see it yet, but I'm very much looking forward to seeing it in full details. I suppose there are really kind of 2 things which come out of this that, if you sort of take it right to the very, very high level, you've got that access to the UK and that access that the UK secures to other countries. And I think the first point, and this is where the Minister was talking about the visa process in the inward visa process in the UK. It's incredibly important that we have a system that is very open. I think the first thing that, when I look at this, is what I want to see is that businesses are going to come and invest in the UK, and that they have a suite of offerings that make the UK very attractive. And our immigration system is going to be one of those offerings. It's really, really important that we maintain our position as the biggest destination of foreign direct investment from outside the 28 nations of the EU into what was a single market of 28 and now will be the single market of 27 plus us. So I think we need to get this absolutely right. And all of these points about simplicity and and clarity and the cost, all of these are very, very important. I did like one thing that was mentioned within the summary, and that is trying to have, if you like, an enhanced offering for those countries that have a trade deal with the UK, with our trading partners. And I think that's a very, very good thing, because it adds an opportunity or another, if you like, carrot for our trade negotiators in order to secure a free trade deal with other countries, where if you do a free trade deal, you get even better inward immigration rules into the UK. I think the other point there, which is also incredibly important, and this I think is probably going to come up more, is our ability to secure better access in other countries for those people within the UK who want to go and do work overseas for one reason or another. And again, it comes back to, I look back at when I was an investment banker, the markets I covered were Southeast Asia and China and Hong Kong, and all my clients were in mainland Europe. So I was permanently having people coming over from Asia and doing roadshows around mainland Europe in terms of launching IPOs and whatever it happened to be. And if we had hassles with getting people into the country, it would just basically close our business down straight away. So it's very, very important that we manage to secure that access of people from the UK getting into other countries. Europe is obviously very, very important, but actually it works when you go to America, it works when you go to any other parts of the world. You can be going along and trying to win deals in Africa. If there's any ambiguity about what you can and can't do, it makes it incredibly difficult. But that, I suspect, is more of a problem of the countries you're trying to do business with than it is the UK problem. But it does make it incumbent on our trade negotiators to be able to secure that access. And of course, when you look at a country like the US, not only have you got the federal rules, but you also got the state rules, and that's a whole different set of problems in terms of recognition of qualifications in individual states. So I think this is a very, very good report. I think as I say, the important point is we are a global nation. We're a global trading nation. What we have to do is I think, to a certain extent, set an example of what global immigration rules should look like, and set rules by which we would expect others to obey and implement in their own countries.
Mark, thank you very much for that. I'd like to turn to questions, and as I said earlier, people can use either the Q&A function at the bottom of their screen, or they can email me directly. But one question that's come up is the extent to which the visa regime, the immigration regime, is increasingly becoming hardwired into thinking around FTAs. So when we think about costs, when we think about attractiveness, when we think about the use of mobility issues as a mechanism in FTAs, and the point's been raised here about the way that the India discussions between the EU and India founded on this issue. Is this something that the UK needs to build in much more holistically as we think about FTAs? Have we done that? Have we done that appropriately? Sally, would you like to kick off?
And the quick answer is yes, we do need to think about it holistically. There is language in trade that already allows for mobility provisions. For us, we refer to Mode 4, which is one of the mechanisms to provide services cross-border, and it's serviced by natural persons, which is typically inevitably done in person. The issue is not so much in free trade agreements that mobility isn't recognised, it's that so many countries seek to carve out from their Mode 4 commitments their own reservations that make it materially harder. What we need to do is to be looking to reduce the number of reservations in the UK free trade agreements rather than to invent a whole new language, I think.
Thank you. Professor Barnard?
Yes, I probably agree with that. The way that GATS works is very different really to GATT, and that countries sign up by mode and by sector, and there's some extraordinary carve-outs which make it very difficult for individuals to provide services in those countries. And so what FTAs do is to try and simplify those carve-outs, but in fact What we don't see in the FTAs is really very radical change. The area where there is most radicalism is, of course, in the EU rules on free movement, which are of a different order of magnitude. But the GATS treaty, that's the General Agreement on Trade and Services, one of the multilateral treaties of the WTO, is really very limited in its ambition. And if you do a survey, as your report has helpfully done, across the more modern FTAs, including the Canadian CETA, that's the trade agreement between the EU and Canada, in fact, what's being offered there is of really very limited value. One of the interesting things in the UK's ask in its own free trade agreement is for actually a very ambitious ask in respect of mutual recognition of qualifications, which is a further issue which is of significant relevance to this field. If you look at what the Canada deal says, the Canada deal is very unambitious. It basically says we'll set up a talking shop and we will talk about those professions where there might be a process for recognising qualifications. And it's deeply disappointing. And the UK is going much, much further in the FTA, but I'm told that that bit of the FTA has already been dropped, but I may be wrong on that point.
Thanks very much. Mark?
Well, I probably have much more to add on that, but of course, as soon as we start talking about mutual recognition of qualifications, we're moving away slightly from the sort of the visa requirements in terms of travel, because of course, what a lot of this is, and again, my experience was telephoning people in mainland Europe. We're doing a Zoom meeting now. Now you no longer have to actually visit these countries, but of course, you can't necessarily go and flog your product around the US without having mutual recognition of qualifications. So there are sort of slightly different elements coming into this already, which as I say, are we looking at trade deals? Are we looking at ability to sell stuff? Are we looking at ability to visit a country? And so already it illustrates how ferociously complex this becomes at a very early stage.
So another question that's come in is, what do people see as the impact of COVID? Obviously, as you've touched on, Mark, we're doing this via a Zoom call, but what do people see as the impact of COVID on skills requirements and visa requirements over the future? So a little more of a sort of longer term sort of visionary question. Professor Barnard, perhaps you'd like to kick us off.
I would like to start with a very basic observation that we've all discovered that we can do so much more from sitting in our front rooms. And so there is an argument that a lot of the issues that we are concerned about do fall away if you don't actually need to physically travel, because the GATS regime is largely set up around people physically travelling and moving to another country. That said, I think there've been a lot of people who've been who are using up existing capital, in other words, contacts they already have, and therefore it's much easier to do Zoom events or Zoom engagement with people you already know. But of course, that doesn't pave the way for new connections unless there's still no substitute for physically going to meet. But I think what we would discover is that a lot more can be done remotely. And therefore, there's an even greater need for a bit of clarity around the rules about payment and how the work can be done, and whether there's a need for any visa issues at all.
Thank you. Mark?
Well, COVID has done a huge amount in terms of really shaking up the way people view trade in general. I mean, it's obviously a lot easier in this particular case to talk about the trade in physical goods. Not least because you've had disruptions at borders, so whereas you used to be able to drive a lorry from Eastern Europe, you then couldn't. But of course, the same applies actually ultimately when you're looking at what's happening with people moving around. So we've seen a catastrophic fall off in flights. Also, as we've seen from this flight that came back from Zante the other day, you could easily find yourself on a flight and then, or in a country where you suddenly have to be self-isolating for a fortnight, and that it creates a greater amount of risk involved in the business traveller going out and going around the world. I mean, I think people have been very surprised that actually the extent to which COVID has affected the way our economy works. And Catherine is absolutely right. We're all getting used to sitting around in our front rooms having conference calls around the world. Although I would suspect that the increase in ill health as a result of lack of mobility may be a problem barreling down our way from as a result of us not moving between meetings. But But actually, the longer term outcome of this is if people stop traveling, they stop building their networks, they stop having that face-to-face, that kind of handshake, which actually does count for a bit. It's how you feel in the presence of other people, whether you trust them or not, you want to deal with them or work with them. So I think there's going to be sort of quite a big change. I don't yet think we understand fully the effects of COVID on our economy. And actually that goes even wider into how, some of the people listening on this call will be thinking about how they use their offices. Do you want to spend a huge amount of money on central London office space when actually you could have a huge amount of staff sitting at their homes, you can monitor what they're doing, you can have some of the compliance functions, and they're working for a couple of hours longer a day because they're not having to sit on a tube for a couple of hours a day. We don't know quite where we're going with this and the effects on everything. But I think it will be some time before we come back to normal. But yeah, I mean, it's going to take time.
Thank you. Sally?
Oh, I really miss handshakes. I never thought I would say that, but I really, really do. I'm one of those people who will be first back on the tube when offices resume normally. I think physical travel is absolutely important. And I guess I would sum it up to say I think you can run a business remotely, but I think it's really, really hard to build a business remotely. So I think business travel and indeed central London offices will come back faster and harder than some people are currently predicting. But against that sort of prediction of background and context, I think the real question on how does COVID influence on mobility is really about if we can't travel because of COVID, are we restricted in what services we can provide remotely? And actually, the answer is yes. Potentially we are in the context of certain key aspects of the UK economy. Legal services can be restricted from being provided remotely under certain domestic law provisions in some countries. So, we can't assume that a Zoom call is even lawful under all circumstances, let alone optimal. If we can travel, and I think we will resume travel faster than people are expecting, then all of the things we've been talking about around Mode 4 and visas and short-term business visits and intercompany transfers come right back on point and become exactly the problems that they were before, despite the COVID context.
Thank you. I'm conscious that we're running to time. So what I'd like is just to go around the panel for one last round and just ask for everyone's view on what is the single most important thing that the UK now needs to do in this space. And Catherine, perhaps I could start with you.
Yeah, so it clearly needs to have the new immigration system up and running on the 1st of January. I was encouraged to hear the Minister say that it would be phased in, but that does raise questions given what's going to happen if you're in a sector which hasn't been benefiting for whatever the phasing might be. I also think the Home Office has got to be seen as a more user-friendly department. And that's where the settled status scheme has been positive, not least because there's a phone line, well, there was a phone line prior to COVID, which was staffed by helpful people who gave good and helpful advice. And that is a really important step forward because visas are an impediment to bright people wanting to come. We have got to be out there saying, look, we are welcome open to business and we have a department that is customer friendly.
Great, thank you. Mark?
Well, I'd agree with that. I mean, I think the most important thing we've got to think about is that we are a First Nation, very commercial country, and that our prosperity depends on how well we perform on a global basis. And in order to be able to do that, we have to think about our immigration policy almost as a commercial activity rather than necessarily as a social activity. And if we get that right, then we are presenting an offering to our potential customers, which is the rest of the world, where they will want to come and do business with us because it will be clear and it will be easily run, it will be manageable, it won't be overly expensive, it'll be something that people will want to engage with. So I think that the key thing that I would take away with this is to have somebody running the Home Office or running the immigration side of the Home Office that is a business person, somebody who understands the commercial ability of all of this sort of stuff, rather than necessarily seeing it as a sort of political headache that has to be dealt with in some sort of dull function of Whitehall that nobody else wants to tackle. Make it a commercial department.
Great, thank you. And Sally, last word with you.
I think I'd come back to the report actually in the second recommendation around creating a mechanism that fits between a full visa and a visa-free short-term business visit that will allow sort of 6 months working, because it seems to me that kind of 6-month project-based working is exactly what the country needs to spread skills and diffuse skills from the UK abroad and vice versa, but doesn't trigger any of the concerns that the public has about immigration more generally. And I think that if I were to pick one thing from the report that seems more important than anything else, it would be that second recommendation.
Brilliant, thank you very much. I think that is us on time. So I think all that remains is for me to thank all of those who contributed to the report, to thank our speakers, to thank our panelists, Professor Catharine, Barnard, Mark Garnier, and Sally Jones, and to thank all of you for taking part and participating in the webinar today. Thank you very much indeed, and have a good day. Thank you.
Thank you.